Welcome to the grey area, where we talk about the spaces that are black and white, and we also talk about accountability, responsibility in the law. And today's session is about class actions. And class actions has become not just a tool for accountability, but a growing business itself, fueled by attorneys, financial incentives, and litigation finance. And today we have two experts here joining us, insurance lawyers, who I'm sure spend a lot of time thinking about this.
Do you guys really spend a lot of time thinking about this?
Spend a lot of time thinking in general.
Yeah, that's good. Good to hear. So, welcome Krianka and Ina. Just a bit of a bio about Krianka and Ina. Ina is a director in the litigation and insurance team at Deneys. She specializes in complex insurance disputes, including property, liability, professional indemnity claims. She advises major insurers very well, and on policy interpretation, coverage issues, and high-stakes litigation. And she has been recognized by best lawyers.
Well done.
Thank you.
Yay! Okay. Then we have Krianka Reddi. Welcome, Krianka. A senior associate in the insurance litigation team at Deneys. Krianka focuses on insurance litigation, personal injury, and delictual claims, representing both major insurers and state-owned entities. Interesting. She brings a strong perspective on how claims play out in practice.
We've got a power pack.
Yeah, so we've got a powerhouse here today of wonderful ladies. Thank you so much, ladies, for joining us. We're really looking forward to this discussion. So we're talking about class actions, okay? For listeners who haven't heard the term and are not entirely sure, can you guys tell us, first of all, why do class actions exist in the first place?
Okay, so like one step back. So class actions generally, it's a single action filed by one member, but it's representing and usually quite an enormous class of members where an incident has arisen, and the cause of action is the same for every single person, but it wouldn't, like in the ordinary course, you would have normal, like in the ordinary litigation sphere, what you'd have is those, let's say 10,000 people that are affected by the accident, instituting individual proceedings. And a class action effectively has one representative representing every single member of that class. And class actions run a bit differently because it requires certification at a very early stage. So you have to be certified a class before you can proceed on that basis. And that in South Africa, I mean, all over the jurisdictions, it's governed differently, but in South Africa, you have Uniform Rule of Court 11A. And that deals with certification of actions and how one would go about procedurally dealing with a certification of a big class action, because it's not an easy process.
Yeah.
Effectively, what you need to do is identify the issue. So the issue has to be common to every single person in that class. So you have to delineate, is this person actually affected by that particular issue? And if so, is that issue a triable area of law? Is this something that is important in the interest of justice to deal with? And obviously this is dealt with in terms of the rule, and the rule itself makes provision. So like you said earlier, you wanted to talk about funding. One of the things you have to do is early disclosure on affidavit about how this issue is going to be funded, how you're going to identify the class, what objective parameters have you set in order to deal with quantum of the claim. It's not necessarily determined, it's not determinative, like the quantum or the value of it isn't the determining factor, it's whether it is overarchingly in the interest of justice to pursue that particular claim.
So that's actually so interesting. I didn't know that class actions had to be certified first before it can, because when we think about class actions, I think when we hear about it on the ground, we immediately think kind of these are a whole lot of people that are after money and it's being funded by lawyers, but there are actually set procedural rules in place that make it a bit more regulated than
Instruction.
Yes, than just this kind of money-making scheme, I think. So that's very interesting.
And it's a new development. The rule that Krianka was mentioning, that only came into force in September last year, 2025. So before that, you had a whole host of cases that have basically set out what the certification factors are and explain basically how they are applied. But now there's a clear procedural home for the certification process that sets out exactly what is required.
Okay. And why do you ladies think that class actions exist? What is the purpose of it?
So like at least from my perspective, you know, jump in anytime you want, but it's normally interest of justice litigation. It's public interest litigation. It's when bad things are happening to a big group of people, it becomes more important to litigate on a bigger scene, because what you're doing is you're saying, okay, this is the teachable moment for corporates, for insurers, for the public in general, for people who obviously don't have the money to litigate on their own. They can now become members of a class. It's an access to justice issue. And so most people would the reason that this happens on this level is because most people can't afford to litigate that individual claim that I spoke of earlier, especially emanating from one cause of action. So as Ina said, like you have the litigation stream where you'd see like Nkala or the big coal miner action or the lead poisoning. You see, those are the kind of examples that you see where it's the most disenfranchised people that need a voice and they need that access to justice, and that's why these kind of claims like show up on the big screen.
It's that mechanism to promote that social justice, right? To fight for those without a voice, but collectively.
Yes.
Do you guys think that class actions are increasing, or is it just that we're hearing more about it in the media now? So is there actual frequency in class actions, or is it just a lot more visibility?
I think it's both. There's definitely more visibility, I think, with anything that happens these days. And certainly overseas, I think you've got a huge increase in class actions. I don't think we've seen that same level of increase just yet in South Africa. It's increasing in South Africa, but more at a steady, reasonable pace. It's not something that has, exploded in the last couple of years.
Yes, What type of claims typically become class actions?
Right now, it seems to be more consumer-driven securities claims. We're seeing it in a lot in this span of personal injury, third-party liability. So notable examples will be so in South Africa, you'll remember the Tiger Brands listeriosis case. That was a lot of people. I think about 200 people died. I think the number was 820 infections. So that one was a big notable one. And then right now you have that 60 billion rand class action against the banks by former homeowners whose houses were sold when they defaulted on payment.
I did see that.
So that's one of the real big ones, and that would give me nightmares as an insurer or any one of the corporate commercial banks here. On the international scale, you have the Lululemon greenwashing campaign. I mean, that one went a little bit awry because there was an allegation that the company put forward a whole lot of information about how they were structuring their business in a way that it would reduce its carbon footprint, and that they were going to be entirely off-grid at some point and have 100% renewable energy-based products. But that one fell apart because there was an issue with the way the allegations were made, and it didn't actually establish a commercial loss. So that one kind of failed. But again, Lululemon now has the big securities one, where it's an action against the company and its officers. And what's happened there is, and it's starting in 2024, so it's still ongoing. And I'm actually looking forward to see how that story ends, because it was directors and officers who allegedly didn't inform their shareholders exactly what was happening, and one of their big product launches tanked. And so what happened was the stock price dropped. And so it was all the investors that have said, well, now that you actually didn't inform us, you omitted certain things, you misrepresented the position regarding that particular launch, and that's what affected the stock value. So that's one of the big ones that are coming up. But I mean, it's so varied, because accidents can happen in any way.
Yes.
And they can happen in the most random way. So with Tiger Brands, it was a product liability issue. Now it's securities, and so there's a lot of competition elements. You get them also with Nkala, it was the health and occupational safety issue, where people were, it was in the mines that people want, silicosis.
Yes.
I mean, those are the big ones that we see.
I wonder who actually monitors these trends to see I mean, there must be someone, right, that's out there monitoring to say, this is a potential class action that we should kind of gather.
It's probably the
claimants for.
plaintiffs' attorneys that that are going to be pursuing the class actions that are monitoring.
I have actually come across a few firms. If you go onto their website, you're going to
Yeah.
have a list of all the notable class actions. So you can actually see for them, maybe that's their primary focus, to take on these type of matters.
Yeah.
And like you mentioned earlier about the Rule 11 one, I mean, from a DNO point of view, it just emphasizes the importance of having that type of cover, because I mean, the cost of something like that would be substantial in that sense.
I mean, with any class action, it tests the scope of your policy.
Yeah.
In any way, like it's always going to have that effect of testing every limit of that policy, testing coverage, testing, because no one is ever underwriting a policy and then they go, oh, you know what we should be doing is preparing for 10,000 people to institute proceedings. No one's really assuming that that's going to be the outcome. When you're looking at like third-party liability, you're going, 500 million seems okay until you have 10,000 plaintiffs.
And it's considered one claim.
Yeah.
Yeah, it would be one claim, but I mean,
As long as you've got your your clauses that
your
can aggregate.
clause is an aggregated clause. Yeah.
But I think it's still a shock to the system for any insurer, because normally you expect, coming from a claims point of view, you're dealing with one matter, and then to see all these plaintiffs filing up, it also becomes an admin nightmare to like manage that file as well, on how you're managing from the claim side. But I mean, having one set of legal team makes it so much easier in that sense.
Yeah.
I mean, the intention is to limit the costs of
Yeah.
pursuing the litigation, because there are these common issues that affect all the parties.
Yes.
If you have one set of attorneys with one set of experts, overall the cost is a lot less than if you had to pursue each claim individually, where it would probably not be economical in any
And also
event to do it.
strategic. I mean, strategy-wise, you need to have a strategy aligned. Since we're talking about insurance, right? Why are class actions such a huge concern? Or why should insurers be worried?
Yeah. Well, I mean, I think it goes back to the nature of liability insurance. You have your insurer who is providing liability insurance to an insured, and they're going to indemnify them for the exposure that the insured suffers when they get sued by a claimant. So if you take the example of an insured that causes harm to hundreds or thousands of people at the same time, perhaps that loss is quite small for the individual claimants. So if you're a claimant and you've suffered 50,000 rands worth of damages, you're not necessarily going to pursue that action against a big corporate, let's say, for example, because the legal fees to do that are going to eat into the amount that you're claiming very quickly and overshadow it. But what the class action mechanism allows is for that to really just become one massive claim by all the affected individuals that, let's say, opt in to the litigation. So what it means is that whereas before you may, as an insurer, maybe get one or two or several of those individuals coming after the insured and you having to defend that litigation for a significantly smaller overall amount, you now have the totality of those claims and you're facing, as the insured and as the insurer, a much larger exposure than what you would otherwise have.
But I mean, for corporations, I think it's important now for them to sit with their brokers and insurers and be alive to the fact that this could happen really to anybody. Because if you think about it, the normal structure of a policy now, I don't really think it caters adequately for a class action. What do you guys think?
I think it does. I mean, it goes to, is the insured properly covered? I mean, we spoke about it briefly, but is there actually an appropriate limit that covers the insured for their potential exposure? It could be something that's covered in the policy, but if you only have 10 million rands worth of cover, that's not going to help you when you're facing a claim of 50 billion. That's got the serious potential of completely ruining your business. So I suppose it's about awareness as well, and just having the broker also that can advise on, are you in an exposed industry? What could potentially go wrong, and do you have sufficient cover?
Yeah, and I mean, even if you if there's a minute chance of you being involved in a class action. Okay, free advice to insurance companies. People should explore the option of maybe getting an add-on at probably a smaller, at a cheaper price to be able to cover you in the case of a class action. There's so many ways I think that you could do it, but use your imagination to make it work from an insurance perspective. But I mean, as you said, if you have 10 million and you've got a whole lot of claimants, it's not even probably going to cover the legal fees of the class action.
I mean, that will go in such a short period of time, and then you still have the long tail of that action and the consequences. And what about the reputational damage? Because we've seen how, when you hear of something, it's out there in the media already. You know that everybody knows about it.
It's always preceded by an inquiry, and those inquiries also attract fees. A lot of the time, we've seen a lot of these spent on the inquiry before it even gets to a litigation stage. So there's a lot of factors that you have to consider, I guess.
Because I think when you're thinking of like inquiries and stuff like that, it's almost the moment the news breaks, there's someone watching, right? And you'll normally be on someone's watch list for something that's going to happen. And it's just a matter of time before they start to investigate further or take the matter further, whether it's from the attorneys or anybody, even a litigation funder.
Yeah,
you could say that.
Yeah.
But have you ever seen them like it always gets me because I always wonder, like, in terms of like pricing, right? You have this huge risk. How do you think they price, or should they price? So I mean, that must be such a difficult situation to
how do
insurers.
Yeah.
I mean, I think it's a challenge.
Yeah.
I mean, I'm not an underwriter, but generally how it works is you'll know that you look at what's happened in the past and then you project going forward.
Yes.
The difficulty, and particularly in South Africa, is that you don't have a very large history of class actions that you can use to model what the potential or likely exposure is going to be. And you've got overseas some insurers that have been caught out in that way. And for that reason, what they're now doing is they're actually trying to implement more forward-looking models rather than simply using the traditional historical basis for underwriting the risk. So that could just be looking at emerging trends in litigation, and specifically class action litigation, and modeling scenarios. And I think what helps us from a South African perspective there is that we can see what is happening around the world. And we often follow what happens around the world. So if we're looking at emerging trends, then all we need to do is just look at the types of class actions that are being instituted worldwide and know that those are the risks that are going to be facing our own insureds in the near future.
And I think we've touched on this in a few episodes before, that before we used to feel so far removed from everything that's happening overseas. We didn't think it was going to hit our shores, but the rate at which trends are coming into South Africa is so fast now that you can't really afford to ignore what's happening overseas anymore, as you said.
Yeah, it is like the global village, like the ripple effect eventually hitting our shores. And I just feel in insurance you should never say never, right?
You should never say never. I mean, it's scary actually.
Like, and I've always wondered, right? Have you ever heard of anybody withdrawing cover or changing the policy terms and conditions based on what's happening at that time? Say, for example, there's this class action. Have you seen any knee-jerk reactions in the market from insurers where they said, okay, we don't want to cover this, or we're limiting, or?
I think not yet, but I mean, we saw what happened with COVID, for example. I think again, we don't have a very large set of precedents and examples of South African class action. Certainly we're seeing more of it, but I don't think it's at that stage perhaps where insurers perceive it as a real risk. Nevertheless, I mean, as with any emerging risk, insurers are going to need to think about what they are and what they're not willing to cover, and for which particular sectors they're willing to provide that cover, because there may be and reasonably so, some sectors that are more exposed than others. The expected fight that the insurers and the insured are going to have is around the policy limits that we've spoken about and aggregation. So, and again, you may have a very large claim in the billions, and your policy limit may be dwarfed by that. So where you have 1,000 claimants, for example, is that one claim? Is it more than one claim? That it's worth it to have that fight from an insurer's perspective. I suppose from an insurer's perspective as well, and to make sure that your recurrence and your aggregation clauses in your policy are clear insofar as what the intention is and how that's going to be treated. So I think it's worthwhile just having a close look at that again in the context of all of this.
I mean, not to get too technical, but it usually says one single originating cause, right?
Yes, that's right.
And I mean, I think,
and I just,
I'm coming from an insurer's perspective, but if you're right, if I wasn't insured, I would fight that.
I would be like, straight, no, guys.
You know what? Mine is a bit different.
Because I mean, if you think about it, if you're in that spot and you think about the implications of this, I mean, if you're not adequately covered, I mean, there's a substantial outcome or situation you may find yourself in that has a ripple effect, not just on your company, but I mean, people that are working there, or I think it extends to a bigger social impact as well. Because I mean, if you have to close your doors and people are not working, and then we have another situation. So
yeah, absolutely. Look, on that occurrence issue, I mean, there is case law on that, and there's a whole bunch of unifying factors. And again, we go back to COVID, and all of those were issues that were considered in those cases as well. So those would need to be analysed.
From an insurance perspective, I don't think that argument is ever. It's resolved through case law, but I don't think it's ever going to not be an argument that is fought by somebody. When there's one limit versus 10 limits on the line, you will fight that. You will try your luck. Yeah. Do you guys think that breach of privacy claims are the next wave of class actions?
Yeah, I mean, that's widely considered to be the case. And I was just looking at some stats on this. And between 2022 and 2024 in America, the incidence of those types of claims increased 150%.
What?
I'm sure since 2024,
it's a lot more now.
It's a lot more.
Yeah.
And in South Africa, you may remember there was a large pharmacy chain a couple of years ago that had the data of, was it 3.6 million customers that was that was breached. And the pharmacy chain, they faced a potential regulatory fine, which they ultimately got out of. But the potential class action there, I think, would have been the far greater exposure.
Yeah. And what about climate-related claims also?
Yeah, absolutely. I mean, again, stats are just useful to contextualize it. And as at the middle of last year, there were over 3,000 climate litigation lawsuits globally. And the defendants here, I mean, they can be governments, they're usually corporate defendants, and the objectives of this type of litigation is usually to change policy or just promote more responsible corporate governance and accountability. Exactly. You've mentioned the Lululemon
greenwashing.
That's mentioned already. That's an example of that.
It's increasing everywhere. You can see it in the Australian market as well. If you just do a quick Google search of climate-related class actions, it's popping up everywhere.
But I don't think ESG is talked about enough in South Africa, considering how important it is and how scary it is, because those type of risks can happen at any time. So that's probably something that we need to think about a bit more.
There's some complexity, who benefits? Okay, at the outset, let's start there. We'll deal with the litigation economy question, but who benefits is, at first, it's the members of the class. So that's the top tier. Those are the people that would never in the ordinary course go and have this access to justice. They benefit first. They're compensated, whatever the outcome is. In the ordinary course, they'd be compensated for their loss. Then you have, I would say, members of the public. Because again, these class actions are teachable moments. It's everybody getting together and going, okay, we all view this as something that's not correct, and people deserve to be compensated for whatever loss they experience. Then you have, it's teachable, like I said, the teachable moment, it's for corporates. If you're going to go and do non-disclosure and you're going to misrepresent your position and you're going to go and do these things, then obviously like it's the teachable moment. And then as attorneys, like you do get your fee, but that's all you get. And maybe you get some spotlight for having dealt with it, especially if you were the person representing the class. You get that spotlight and maybe a little bit of good market, like, just a good view of you in the market. But you work hard and you get paid your fee. That's the beneficial, like the beneficiary level. But a litigation economy is a little bit of a difficult one because, like I said, it's very difficult to actually objectively form part of a class. And if you, especially in opt-in litigation, you need to be able to establish that you objectively fit into that particular class of people that suffered that loss. So in personal injury claims, you'd either have to be the person that was injured as a result of the accident, or someone who's experienced a loss and now you're raising a dependence action for loss of support because the person who maintained you died in the accident. And so you're limiting. People become a lot less opportunistic on the opt-in claims because you have to establish that you objectively form part of that class. So you've weeded out majority of those people you consider opportunistic litigants. But where it's opt-out, it's different. So there's you representing an entire class, but nobody's actually fully investing in being part of that class. So unless a person says, I'm completely disinterested in falling part of the class, you're representing everyone. So that's that real common interest litigation. It's a big public interest litigation where the public will benefit from it, but nobody can really be construed as being opportunistic because it's
checks. But I like how you said earlier teachable moments, right? Because normally, like when you have situations and just say it's involving a corporation and a man on the street, people think of, you know what, there's no chance of me getting justice. But when you see these judgments coming out, you see that, okay, this may be the catalyst which enables society to fight for their rights, to change how things are going if there's been a situation where someone has been harmed and there's been exploitation. So I see the benefit in how these moments can shape society as well. So it's not just about the accountability, but it's the impact on society and how you can enforce your rights.
I do love how you looked at that from not just a financial point of view, but from a societal point of view.
Yeah, it's like such a
good person.
We love you, Kate.
I think it's important though. Like I think these actions are difficult because everybody views them differently. Like the insurer will view it differently, the insured will view it differently.
Right?
I mean, the public views it differently. And with these class actions, it's what you're seeing is the world is actually becoming a lot smaller. So with class actions developing all over the place, it's becoming teachable moments for everybody. And people should be moving in a direction where we like, if we're doing the wrong things, let's fix it. If, as an insurer, we don't want to cover these risks, let's model a scenario and determine whether we want to underwrite these huge risks, or if we don't want to underwrite it, how can we help our client, the insured, cover themselves? You know what I'm saying? There's ways of doing this, and we just have to become a little bit more creative. If we can try and avoid these situations, we can't avoid every single one of these situations, but we can cater to the eventuality of it happening and see, okay, we've got our contingencies in place, we've got the right people doing the right work at the right level, sorting things out. And that's what the common man on the street needs. They need people that are good at what they do, helping them get that justice that they need.
And I think it contributes to that sustainability from the economic point of view, but also the sustainability of our society, right? So it is always going to be this ecosystem. So you play your role in what you do, we play our role, insurers, everybody plays their role to advocate for something better. I know I sound like Miss World now.
And you look like Miss World. So I never thought about it that it was an ecosystem the way that you guys are explaining it, but it really is. And I think that probably if you delve a little bit deeper into it, people are going to follow this route because it gives them justice at the end of the day, and also it holds people accountable. And I think accountability is something that has been lacking to such an extent. Can you give us a real life example of a class action?
South Africa has got a really a lot of good ones, but Merrick's was a really interesting one because it affected people's pockets directly.
Yes.
So Merrick's is a gentleman. What happened was, and it was interesting because MasterCard, and you know MasterCard, it's a huge brand, right? They had, from about 1992 to about 2006, they were charging people an additional sum on their card when they shopped at certain retailers. So what it actually was, it was a fee that was being charged to the retailer, which the retailer then just added to the customer's product, right? So Merrick's said, well, this is not right. This seems quite unfair. And Merrick's instituted an action on behalf of tens of millions. He wanted to institute proceedings in the competition tribunal in the UK. And what happened was, he said he's going to do it on an opt-out basis, but he's instituting on behalf of tens of millions of people who had paid and using their MasterCard in that period. And the reason it is quite, it's a good judge, it's a good case, because it sets the tone for what was acceptable or not. Because I mean, that was an unquantifiable amount of money, right? And so there's this misconception that you need to be able to quantify an amount before you can proceed with certification of the class action, because you want to know what the value of the entire claim is. And sometimes you just simply can't do that. You can't ask 10 million UK citizens who were paying money over that course of time to tell us exactly how much they paid, and it's very difficult to establish the quantum. So Merrick's goes to the competition tribunal and he says he wants to have the action certified, a class action on behalf of all these consumers, and the tribunal says, no, we're not going to allow you to certify. And the reasons are that, one, we don't really think you're authorized to act on behalf of these people. We don't think that the amount is quantifiable. We think that there is a suitability issue, and there may not be commonality towards everybody that we needed to opt out. And so eventually what happens is they say no, and he goes to the Supreme Court. And the Supreme Court says, sorry, they call it the CAT, the Competition Tribunal, you're wrong, simply. This is a specialty form of litigation. And he's permitted to do it. And so we're going to remit this back to you for reconsideration, but you've got it wrong on most fronts. These actions do not need to be quantifiable right at the outset, because what it actually is a determination on liability. The real question is, did this happen to all these people, and are you liable for that loss? And so they go on, and it's a very interesting judge, and I thoroughly enjoyed that one. But I mean, there's a lot more South African cases.
Can I give a saucy example?
Go.
Yes, of course.
Okay, great. It's not a South African case, it's a US case, and you probably have heard about it. It's the Ashley Madison scandal that happened in the US. So for those people that don't know, online, Ashley Madison was a website I don't know if it was only in the US, but in the US specifically, that catered to married individuals that were looking to have extramarital affairs. And I think their slogan was, and still is, life short, have an affair. So
Good
at
advice.
some point, I do not subscribe, philosophically or otherwise. So at some point, the data of 37 million users of the site were hacked and were released, which caused lots of trouble in many marriages, but also resulted in a class action, which was ultimately settled. But that's just, I mean, it's another data privacy example of how things can go horribly, horribly wrong.
Yeah.
Very saucy, eh? Also, it makes you think of a lot of things, like, you know, in the person's ways, trust and all of that. So yeah, I also don't subscribe.
You play with fire. You could.
It comes back to you, right?
Something's
I mean, you
gonna
would think about it. Okay, you did this. Your karma came back to you. You know, but
I mean, the owner of Ashley Madison was actually one of the people that was exposed as subscribing to the website despite being married and claiming to be happily married.
But she could have just said she was like technical support or
Product testing.
Product testing.
Moving along.
No, we can.
After that.
yeah.
Okay, so what lessons can come out of cases like this?
You mentioned it earlier. It's the aggregation issue.
Yeah.
I think it's like one of the things that it's the foreseeability issue.
Yeah.
That people, I mean, from the insurer perspective, you should be testing scenarios like this. Like, especially when you're underwriting risk, one of the most important things is like, I mean, I don't think people expected polony to cause such a scandal in South Africa,
yeah.
but single product testing and just thinking about one product liability issue and what the eventual outcome could be internally, and like from a corporate perspective, it would be like, what are we representing? Like, what are we saying out there? What are we disclosing to the public that may come back to bite us later? I mean, at insurance level, so like you want to think about like your policy wording, and sometimes you're going to start thinking a bit more creatively about, if this scenario were to unfold, what would you want your wording to be?
Yeah.
And what would you want the limits of your cover to be? And what would you want your client relationship to be if you had to tell them, sorry, you're not covered for this 10 billion rand class action that just showed up on your doorstep? I mean, there's a lot of perspectives that you need to look at it from and try and hit a nice, easy middle ground.
From an insured's perspective, I think the lesson is just in looking at what is happening globally and in South Africa is just how exposed you actually are, and how things can go wrong from a liability perspective in so many different ways. So just suppose reinforcing the importance of insurance cover across the different liability covers that you can take out.
And I think from an operational perspective, I don't think we see this enough in insurance companies where they do they do catastrophe planning, but to do planning for if you are hit with a class action, who are you going to call, how are you, scenario planning, that type of thing. It needs to be a lot more intentional. And we come from an insurer background, and it's simply not done. And even if it is done, it isn't done with the appropriate contributors. So I think if you're going to do scenario planning for class actions, you need to sit down with your attorneys, you need to sit down with your loss adjusters, specialists, experts, all of those people to have a plan of what's going to happen when it hits you. Because I think if you are being kind of reactive to a class action, that's where things go extremely south. And the people that suffer at the end of the day are the ones that are not getting the full benefit of your limited limit, I think.
But also, I think a lesson for insured, if you see something happening in the same industry, I mean, you need to look internally in terms of your operations and mitigation measures and planning as well. Because, I mean, prevention is better than something happening out there, which may damage the image of the company, or now you affect your loss ratio because your insurer is going to pay, or your own pockets. So I think risk mitigation is a big thing as well.
Yeah, and from a public relations standpoint as well.
The reputational harm is severe. If you're slacking on any one of your IT, legal, cyber, corporate governance, disclosures, you're going to end up with much bigger issues.
Yeah, definitely.
Remember, once you're on TikTok, you're out there.
There we go. The world is a small place now.
You've made it.
Social media.
Good or bad.
If you have insurance nowadays that doesn't cater for some type of public relations cover, I think you are not
so important.
You are not with the right insurance company, basically.
And I think that's so important because it's the message you want to relay, right?
Yes.
These are your clients that have trusted you, and this is happening, so you need to make sure that you're the authoritative source, and what you're putting out there is so important to protect that brand image.
We always say when we first started in insurance, our line used to be, your reputation is not our issue, but that has evolved so much over the past few years. As an insurance company, you need to be protective of and as a firm of attorneys, you need to be so protective of your client's reputation, because that reputational issue can potentially put them out of business.
We're both in service industry, and our first job is to make sure that our clients are happy with the products and the services that we're providing, and that we're doing our best to make sure that they have the best outcome. That's what they pay you for as an insurer. That's what they pay you for as an attorney.
Yes.
We try and give the best advice we can. We try and make sure that we're treating you as fairly as possible, and that's the baseline of our relationship. It's trusted relationships, and that's what clients want to know at the end. They want to know, can I trust my attorney enough that they're going to do the right thing? are they advising me correctly? Is my insurance in place that will cover me if this should eventuate? They want to know that they can trust their brokers. They want to know that the policy is written favorably for them,
Yeah.
and that they actually are seen and that their business is understood. And I think a lot of the time, like people, especially with these big class actions, you can always see that there was a gap.
Yeah.
There was a gap somewhere where it was either completely unforeseeable, and that's why it happened. It was just something that nobody thought would ever happen.
Yes.
And then you look at like the more corporate ones where it was like a disclosure that should never have happened in the first place, or a big marketing campaign that should have never gone out without an oversight somewhere.
Yeah.
And so you always, this is where these things come from. It's all these little gaps. And I think now,
I mean, it just highlights actually how difficult it is to plan for a lot of the things that can go horribly wrong. If you don't foresee risks, and you can't foresee everything, and that, I mean, that's where your big exposures normally come in from an insured's and an insurer's perspective. It's because you simply don't have a crystal ball
To predict.
because there's developments in science and health and all of that, and new issues are picked up as to how people can be affected by certain things. There's just I think it's just very difficult. It's not an easy position to be in as an insurer or an insured.
It's hard, man. Humaning is hard.
I think we need to get in-house psychics. Trying
to see what's going to happen on the next show. So we're doing rapid fire before we close off. Whatever comes to your mind, limited to ascendants, right? What is the biggest myth or misconception about class action?
That everyone shares equally in the pot at the end.
I'd say it's that attorneys are the only ones that benefit.
Same then.
Okay, my next one is, which industry do you foresee seeing the biggest impact in the next 10 years?
Cyber, IT, or any marketing industries out there.
What she said.
Yeah.
Okay, ditto. And the last one, what do CEOs underestimate?
The need for insurance, proper insurance, comprehensive insurance.
100%.
No, I stamp that. Sorry.
I concur. I concur with my colleague.
So, ladies, we just want to say thank you so much for being a part of our episode today and giving your insights. You ladies are so amazing, smart, knowledgeable, everything that we want to be one day when we grow up.
You made us look good.
Thank you. It's
Thank
easy
you
when
so much, and we hope that you guys will join us again in the future for another
Thank you.
episode.
We'd love to. Thank you.
I'm going to do. Can I do a quick sales pitch?
Of course.
Yeah, go for
Oh,
it.
wonderful. All I wanted to say was that we have a publication coming out on class action soon.
Oh, lovely.
Check it out,
I
everyone.
think it's going to be one of our first as Deneys. So
Yes.
keep a lookout for that if you want to learn
We
more
will.
about class actions.
We will share it. Thank you so much,
Thank
ladies.
you.
No.
Thank you.
Thank you.